Thank you, Governor Bird. Mr. Neketel, I think the questions are very straightforward. If you could prepare some responses to those. You can speak, obviously, and answer some if you can off the top of your head, but some written responses would be good. Indeed, it's very alarming that this is happening. Did this ring any alarm bells at all in your organization? Like, does your organization have an entity that would say, we're looking at these figures and we're very concerned that something's not adding up, so we're going to send a team to find out what's going on? Was that a consideration ever by your organization? And if so, then do you think it's a capacity issue? Does your organization have analysts, investigators, people who are qualified to go out there and find out what's happening? With, you know, what's happening in the world is that the gold price is shooting and continuously, you know, breaking records. And production is evident everywhere you care to look. Wherever there's alluvial gold activities, there is, every man and his dog is out there panning away somewhere, you know. So there's more people involved. Then there's mechanized mining. Then we have very credible intelligence. You can see it. You don't, you know, need to just hear about it. If you take a trip to, say, Bulola Wow, for instance, or anywhere where there's alluvial mining, you can see foreign entities involved. So this tells us that there is a huge flurry of activity, but as you yourself have pointed out, production has dropped, and as Governor Bird has stated. So just very quickly, Mr. Neketel, does your organization have within itself a capacity to analyze this information and react? And if not, then why not? Is it a funding issue? What are your thoughts? I'd just like your thoughts on that.
We rely on reports that we get, but we should have the capacity to follow on the reports. If we know that something is not right and report does not correlate or equate to what actually activity on the ground in that, it's our duty to go and check to make sure that you know, people are reporting honestly and correctly. We regulate from permitting to production. Post-production commercialization of valuable minerals is the responsibility of the bank, central bank. So we assist in providing stats on the production, but when it comes to permitting exports, the bank takes over that responsibility. So we do collaborate with the bank to try and check gold, authorized gold exporters to make sure that, you know, what they produce for export, they do not conceal things in their exports, all of that. I think it really has to do with our borders and its tightening. To check properly, there's a lot of compromising, I would say, that allows these materials to get through our borders. So again, as I say, exporting, commercialization is the responsibility of the bank. We don't permit that. We just assist to make sure that you know, activities leading up to that are done properly according to our law.
Mr. Neketel, sorry for interrupting. Does your organization have enforcement capabilities, say, to carry out an investigation and prosecute? So, for instance, we've got organizations that are lodging these reports. Now, it's common knowledge that a lot of organizations are not giving you the right information or, you know, factual information, because it's also common knowledge that there's a lot of illegal exports taking place, smuggling, if you will. In fact, I think just not too long ago, customs intercepted a significant volume of gold that was about to be smuggled out. And I want to put on note here that we have MRA, central bank, as well as customs here. The other organizations that we asked to turn up that have not turned up are the Labor Department, Migration, and the Environment Protection Authority. So we will be sending notices, but since this is a public hearing, I want to mention this so that the people of our country know that these organizations, for whatever reason, have not bothered to turn up. They are also very important players in this industry. So, you know, Mr. Negatel, we're going to have a conversation and continue. We're starting to see that what you're basically telling us is that your organization doesn't have the capacity. That's what we're starting to conclude here. We'd like to hear from the central bank. And the central bank here is, actually, it's a segment of the central bank known as FASU. Am I correct? Mr. Onea here is representing that organization. And they were given a separate invitation, so they've come as FASU. So again, we also note that central bank, who had been given the invitation, have not turned up, which is unfortunate because, as you have mentioned, they're the organization that we would really like to hear about or hear from. After that, we will hear from customs as well. They've sent one of their senior officers here, and he can also give us an explanation. But members, if there's any further questions of Mr. Nekitel, please feel free to ask.
Chairman, I have some questions. Mr. Nekitel, good morning to you.
Good morning, member.
All right, I'm from the Bulolo area. So my question, I think some of the questions are from my constituents that that needs to be cleared. Firstly, I would like to ask about the land, especially about the land tenure system. All right, as you know, Bulolo area is not a new district. It's in an existing mining area. So we have mining lease. Not only mining leases during the colonial area, but we also have agricultural leases and conservation leases, and also urban development lease and all this. And in recent times, because of the high price of gold or whatever it is, there's a high activity of mining taking place, small-scale mining taking place. And now people are applying for leases on those agricultural leases and conservation leases over that area. My questions are, can alluvial mining lease AML or a mining lease for alluvial purpose ML can be given over an existing lease like an agricultural lease or a conservation lease?
Thank you, member. As I mentioned earlier, we regulate the law. In the law that we regulate, the only lease that the minister responsible should be consulted is the land reserved. Land reserved under the Lands Act by the minister responsible. That's the only lease that's made reference to in the law. Apart from that, all other leases can coexist. Mining leases can be issued over agricultural lease or vice versa, for different purposes, of course. You don't get an agricultural lease to do mining. You get an agricultural lease to do agriculture. Okay? You get a mining lease to do mining. Resource is owned by the state. State issues leases for the purpose of mining minerals, not for agriculture. So leases can coexist, member. Yeah. For SIPA, yes, the SIPA conservation areas in Wa and Bulolo have been exhaustively converted into mining areas. So the specific purpose for SIPA should be here to explain this, but SIPA will have to advise. We have a SIPA rep sitting on our mining advisory council that advises the minister on grant or on issuing of the lease or not to issue leases. So they are the ones that advises whether we can issue leases on conservation areas or not. So they are always consulted when the mining council sits to deliberate on mining lease applications, whether on SIPA conserved areas or not. So we listen to the advice on that. We know from SIPA there's a conservation area which I think should really be de-gazetted. You have to gazette a conservation area to make it effective. This specific area in Wabulolo is still active, but the purpose for which the conservation area or license or permit has been issued no longer serves the purpose. It is, I think, for the local pine trees or something. There's no longer, fires have destroyed the pine trees and there's nothing existing at the moment. So it's taken over by alluvial miners and most of them doing illegal. So the place has been turned upside down with alluvial mining. Thank you, member.
Okay, further to that, so an agriculture lease and a mining lease can coexist. Now, who will mine in that? Any other person, or the person who has the agriculture lease can mine on that?
AMLs, alluvial
For
mining.
ML.
For ML, the applicant. If the applicant, whoever the applicant is, it can be any national. Does not necessarily mean the agricultural leaseholder. Any national can apply for and obtain a mining lease for alluvial mining.
Over that agriculture.
Over that agricultural lease, yes.
So
Different purposes. There's compensation provided for in the Mining Act. If your trees are damaged or land, whatever is damaged, you can resort to compensation. Compensation is there, provisions provide for compensating for loss of revenue or loss of whatever commercial trace there is.
okay, I'm trying to ask a question related to lands, but hopefully you can be able to answer that. It's some agricultural leases there over 99 years. So like they say, it goes back to the state. Is that true?
I wouldn't answer you there. If it's an agricultural lease, for mining lease I can answer.
Does it go back to the original customary landowners, or it goes back to the state, the title or whatever it is?
My understanding is it becomes reverts back to the customary. I don't know. The lands people will have to advise.
All right,
provide advice for that.
So it can, when we ask the lands secretary, he'll be able to answer. Okay, my other question. So we have the alluvial mining lease for customary landowners and mining lease for any Papua New Guineans.
Correct.
For alluvial mining lease, how do you verify if the person who applied is a customary landowner? What sort of process you have in place to verify if that person applied is a customary landowner?
Okay. In applications, there are certain things that are considered when a customary landowner or anyone lodges an application for permitting, processing and permitting. One thing that we check for is evidence for AMLs, we check for evidence of land ownership. Because the law says AMLs are reserved for landowners.
Mm-hmm.
So we check for preliminary checks, we check for evidence of land ownership. Do you have a certificate of land registration? If you don't, then there's we resort to, provided for in law as well, we resort to a statutory declaration. Now, statutory declaration is a court document. You declare in the courts or witnessed by a commissioner of oaths that what you're saying is true. You are a landowner to be eligible to apply for the mining lease on the land that you own. We check for those two things. I know I don't have evidence, but when you read through the applications, you will know that certain things can be falsified. I know that then a lot of statutory declarations have been falsified. But as a regulator, we go by face value of whatever documentation that is placed in front of us.
So you can confirm that there is an issue with in terms of verifying the true customary landowner of that AML. That process can be improved.
I think it can be improved. It needs to be put to the people that you got to follow the law. I mean, you cannot falsify statutory declarations, but you go to court and court assists you in producing that falsified documents. You see, these are the challenges that exist in our country.
So we recently have we are reviewing the Mining Act. Have you contribute or make any amendments to that act to make sure that the process is correct in law?
We make some recommendations in there, but the department, the MPGM, they're supposed to be here to explain. They're the ones responsible for making laws, mining-related laws, drafting laws. We did review the bill and we did make our comments. Certain things that we think needs to be strengthened in law, we have made contributions towards that. It's really for them to, take it in and put it into the draft bill that comes to Parliament.
Thank you. So for AML and ML, alluvial mining lease and mining lease for alluvial purpose, should AML mechanized mining be involved in AML? AML can be, you can use excavator or walking. You supposed to make at alluvial mining lease. Can we use excavator and to dig up the land, or we just have to use the the normal rudimentary process?
Now, going back to the law, in law it says mechanized mining. If you want to engage in mechanized mining, you have to have a proper issued permit, AMLs or MLs. It does not break down the different levels of the mechanized activity for AML or for ML. It just says mechanized mining. So if you're using machines to mine, you got to have leases to mine.
Okay, so you can use mechanized mining in both AML and ML.
I think generally it's captured in law, yeah.
I think, are you not so?
Well, it's captured in law as mechanized mining.
Okay.
So mechanized mining, you have to have permits. There's no specific level of mechanized activity for alluvial mining or for mining lease. So it says if it's mechanized mining, you got to obtain proper permits. AMLs, again, is reserved for landowners. MLs, anyone can do. Yeah.
Okay, for just one question, based on your earlier information, you say we have 51% and 49% benefit sharing between leaseholder and developer, your partner. That's in law. So, but in tribute arrangement, that's formed a tribute arrangement, or it does not cover the tribute arrangement.
Okay, the 4951 in favor of any national, it's ownership or equity participation. Equity, you have an equity in a project, you fund it. You fund it as per your equity holding in the project. So 4951 talks about ownership. I can own the lease, I own it 51%, and a foreigner owns it 49%. Okay, but when it comes to, you have to fund your ownership of the project to participate in the benefits. If you don't have the capacity to fund your equity, then tribute arrangement is considered. So you have a separate agreement with whoever it is that is funding the activity for benefit sharing purposes. Okay, you don't contribute anything to the development. I said yeah, that's where the 20% I mentioned comes in.
Okay.
Yeah. You can negotiate down to 20%. If it's below that, we will say it's not equitable, it's not fair to the whoever the leaseholder is, who then shares with the community or tribute arrangement is where the benefit sharing is agreed to. Okay, it's an agreement, joint venture agreement, tribute agreement. You pass on your rights to another person to mine your lease, but it's going to put up the funding and capital. So he has the right to negotiate for a deal that will settle his investment, cost, and all of that. And then depends on, it is a negotiable thing. You go to negotiate and come up with an agreement. You don't negotiate and it won't be fair. But you see, because of money up front, people just getting money because they want money. You know, they blindly are misled by whoever the investor is, writing up JV mining agreements may not be fair, but you know, when we assess that, it is approved separately. So once we assess that, we see that percentage is not equitable. Or we say, go and revise, do it again, do it properly, so that you know there's fair benefits to the local landowners or leaseholders.
Okay, this is another question about the warden hearings. Now, several of my constituents say that they've strongly argued against the issue of mining lease to the applicants, but most often their arguments are not being considered, and there's no response from MRA with regards to their arguments. They've made written arguments to not to issue mining lease to that particular applicant, but MRA has not listened to them and actually not responded to them, giving reasons why they have not, listened to their arguments. So is MRA liable, or is MRA supposed to respond to those who object against mining lease in a warden hearing?
Response to objections are not required under the law. The council is created or mandated to consider objections. So the objections that needed clarification or needed to be responded to, we try and respond as regulators. Otherwise, all objections are considered by the Mining Advisory Council when the applications come up for considerations for the minister's determination. Considerations by the council, and minister determines whether to grant or refuse. But the advice comes from Mining Advisory Council. One of the mandate is to look at objections, whether it has merit or not. Usually meritorious objections are considered. A simple objection, I don't like you, I like this other person. Mining is a national, is of national significance in the country. You all know, mining contributes a lot towards the economy of this country, so it takes, it's given that special recognition as an activity of national interest. So objections has to have merits. I don't like you because I like this other investor. Would like to promote an industry that has let's say there's a playing field that's equal to all, so that we're not biased against investment in the sector. If we, listen to some of these objections because, I like this one, I don't like that. There's a potential of killing investment in the sector, so we got to be fair in everything that we do. Yeah.
Yes, but that merit or not, that should be communicated to the people who object. The thing is, they are kept in the dark. They don't know why their objections are not being listened to, or, they need to be responded. So is there any way we can improve on that? if their objection has no merit, we should advise them why we have not considered their objections. Is MRA in a process to advise they waste time to go to the warden hearings, they waste time to write that objection, but they have not received any response from MRA why their objections are not being heard. That's a two-way thing. So are you considered any way you can respond to their objections? Why you have not considered their objections? Keep them informed.
Yeah, objections that we feel that there's lack of maybe some understanding about the law and stuff like that. We try to respond and put them at a space where they can understand. Otherwise, general objections goes to the council, as I said, but we are not compelled by law to respond to objections.
Can you make change to the law so that you can compel
Yes.
to the law to respond? This is a consultative constitution we are in. So if people object, they need to be informed. Can you make changes to the law so that any objections to any ordinary, because I'm customary, I'm ground long only. Or less law, to one you must wine receive him. This la talk long, please. Can you make changes to the law? I mean, recommend so that we can make changes to the law. See, I understand that.
I know that. We'll
thank
take
you.
it in, and the bill is still there. I think we got to consider holding on to it a bit. So certain things like what's raised now can be captured in law.
Yeah, thank you. Okay, last one from me. You mentioned that you have capacity issues. You're looking for funding to put in recruit staff and all this. Now, we DDAs and provincial governments, we are signing MOU with the Cocoa Board, CIC, Coffee Industry Corporation. I'm wondering, is MRA and SIPA signing any MOU or MOA with DDAs and provincial governments to delegate some functions to them to perform at the... You are far down at Waigani. And we are with the people on the ground. We know what is happening. The local level government know what is happening at the ground level. The provincial government, the DDAs. Have you signed any understanding with any DDAs or any provincial government to delegate some of your functions to them?
No, we have not, member. Certain provincial governments have established desks within the administration to have an officer there or people there to coordinate between them and ourselves, the ministry, on mining matters. So it's initiative taken by its provincial government. Really, we are not. We are established by the MRA is established by the separate act. It would be good if that act is also considered for review, so that to look at establishing the concern that you have raised for MRA to have officers. We have liaison officers, but we don't have specific officers with provincial governments to look at mining matters, and a lot of issues arise anyway. It's good to have districts, but to have officers in districts. But as I said, it's an initiative. The provincial governments take it upon themselves to establish the mining office within the provincial administration.
Yeah, I understand, but we currently have patrol officers at local level government, and even officers, public servants already existing in provincial government and districts and local level government. So it would be good to utilize them instead of waiting to recruit new people. Some of the functions can be delegated to them to play at that level. Now they are all folding their hands together and looking for MRA to play that role. And MRA is looking to recruit staff. So that partnership can happen. I think you should consider that. And Wawaria, we actually wrote a letter and approached you guys to have that partnership. so that there's some roles that we can play because it is really affecting us at the, at the district level and NLG level. So we would really like want a partnership, so some of the functions we can play at that level to, especially for environment purpose. All digging go there, or else ground, all no disposing western or diverting water about come back up road. This sort of things, you are far up there and you cannot play that role down there. So those sort of things that we would like up. So I'm also concerned for me, if you can consider that, and we can have some sort of partnership at the local level government or provincial or DDA level, so that some of those things you can delegate that functions to us. Thank you. Just for your consideration.
I take note.
Chairman, that's all from me.